I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Dear Lord, thank you for being with us today and for everyone that is gathered here at this meeting. Help us to interact with each other peacefully, and may we agree in all our discussions. Through Jesus' name we pray, amen.
Vice Chairman and Directors, the first item on your workshop agenda is Hidalgo County Regional Mobility Authority Board of Director Annual Ethics and Compliance Training. This is our once a year training that the Board of Directors requires for the board and for the staff. So Blakely Fernandez, our General Counsel, is online and she'll be going through the annual ethics training. Blakely?
Hi, can you hear me okay and see my screen?
Yes, ma'am, we can. We can hear you and see the screen.
Okay, great, thank you. Thank you for indulging me doing this electronically tonight. Like many of you, our office has had a surge of COVID in the last week, and so we're trying to keep distance where we can. As Pilar said, this is our annual ethics and compliance training. It's required for board members and for staff as part of our obligation with TxDOT. Under the Texas Administrative Code, RMAs are required to adopt and enforce their internal ethics and compliance program, and we've got a number of steps that we'll walk through as part of this presentation. A quick overview just to lay the groundwork. Ethics is the conduct, behavior, the things to build the public trust and to avoid the appearance of impropriety. Compliance is the way that we enact that, the evidence and enforcement that supports those ethics. So we're going to talk about 7 key areas this evening. And for each of these, we'll go through the state law, which often is less restrictive than the TxDOT rules. And in some circumstances, we have adopted HCRMA policies that are even a little bit more restrictive than what TxDOT requires. The first is conflict of interest. So if you have served on another board or commission, or you've been elected to office, or you've worked for a public agency before, you're probably familiar with the general state law of conflict of interest. And that is that a decision-making participant, a board member, cannot participate in a vote in a matter that involves their business entity or property in which they have a substantial interest. Substantial I've highlighted here because it's not what you would ordinarily anticipate. The thresholds are very low. A substantial business interest under state law is 10% of the voting shares, or 10% of your total income, or $15,000 in fair market value. For a substantial property interest, we're talking about even a lower threshold of $2,500. If you're an official that has a conflict that's described here, your obligation is to not vote or deliberate on that item and to make a disclosure. If this situation should arise, I'm happy to help you make that disclosure. TxDOT has adopted more restricted conflict rules for their contract parties, including RMAs, and for TxDOT itself. And what you'll see here in these rules is not just that they're so much broader than the state law conflict requirements, but they also have a more fluid standard. You see, where acceptance of a gift might influence official duties, or your employment or professional activity might induce disclosure of RMA's confidential information. So you're really touching into an area here that's a little more gray and that's a little bit more perception based. Basically here in the gray box is a summary of the things that are most likely to occur and that we want to highlight. No lunches, dinners, or trips or entertainment events that would be perceived to influence decisions. No sharing of any HCRMA confidential information. That would be anything that's not yet public. No purchase of land in or near projected right-of-way, and no interest in any RMA contracts. So the consequence if you have a violation of the state law conflict of interest is that you're not supposed to vote on the item. If your vote were the consequential vote, then that item could be voidable. The RMA rules are drafted a little differently in that if you have one of these conflicts, you're ineligible to serve as an RMA board member or as executive director. And so part of what we'll do here today, I think Celia's already sent you the certification. We do this training, and then we'll go through each of those conflicts in your certification. And we do this on an annual basis to make sure that everybody is current with their disclosures to the RMA and to TxDOT, that you don't have any of these kind of employment or business conflicts. And then in addition, because the RMA has ongoing business interests that change over time, we have the standard conflicts disclosure statement. This is the kind of statement you would use if a proposing entity or a new vendor triggered a conflict interest, then we'd want to get this on file for you. Proposers are also required to file these, and so we've got sort of a two ways to catch conflicts in this area. All right, our second topic is bribery and gifts. So the bribery statute is a criminal law statute. This deals with the intentional soliciting, offering, or accepting of a benefit in exchange for a decision, opinion, or other exercise of official discretion. The bribery statute applies to all public servants, so this will be board as well as staff. And you can see there's four elements to bribery. The benefit would be any financial gain or advantage. Acceptance would be in exchange for a vote or a specific action. On these last two, I note that timing, an item can be accepted after the exercise of official action and still be considered bribery, so it wouldn't have to be in advance. And then on influence, it's really more about intention rather than actual influence. So there may not have been actual influence over a decision, but if the intention was there, then you could still have a situation that would qualify as bribery. I've made a note here under benefit. TxDOT defines benefit differently than the criminal law statute. And TxDOT, for example, would include working meals. That's not going to trigger the criminal law statute, but it does offer that second level of authority that TxDOT takes over these kind of benefits and conflict issues. Okay, the state criminal laws provide certain exceptions to the bribery statute. These are non-cash items, entertainment expenses, including food, lodging, transportation, gifts from friends, relatives, or business associates that would be outside of your public service, and payments for legitimate consideration. I've made note of TxDOT clarifications. I want to stress these clarifications don't have criminal law impact, but they do go to TxDOT's concern and their efforts against any type of appearance of impropriety. So TxDOT considers token items that are valued over $25 as benefits that you should not be accepting. That's a very small threshold. They only allow for reimbursement for food and travel and lodging to an official event, so it's not the broad entertainment exception. And then they don't make a clarification on those last two issues. And again, the state law exceptions, these in blue here, are exceptions to criminal liability. The TxDOT comments, their requirements under the administrative code are only about the appearance of impropriety. Use of government property is our third topic. For board members, this really focuses on email systems and information. Staff has access to additional government property. The offices, I think we're in the process of approving some vehicles. They've got computer equipments and other things. And so this is just a reminder that any property that belongs to the HCRMA should only be used for official HCRMA business, and that other uses can qualify as abuse of office. For board members, what we're really most cautious about is the misuse of information, because that's really the only property of the RMAs that you typically would have access to. So, nepotism. State law prohibits appointing or voting for the appointment of an individual to a paid position if that person is related to the public official, as reflected in this red bordered box. So this goes out to the third degree of consanguinity. These are your blood relatives, and the second degree of affinity. These are your relatives by marriage. The only employee that the board members hire is the executive director. So the caution here is to make sure we don't hire an executive director that is related to anybody on the board. Okay, open government. The board members should have already had open government training, so I'll go through these pieces quickly. If you haven't done your open government training, it's something that's required, and the Attorney General's office has an electronic training. I think it takes about an hour, and you'll get a certificate when you're done, and CELIA keeps those on file, and that's all required under state law, so we need everyone to do that. Open government includes both the Open Meetings Act and the Public Information Act. As I'm sure you are aware, all meetings of governmental bodies are to be open unless there's a specific exception, and we'll talk about those. Meetings can be regular or special meetings, and they need to be held inside Hidalgo County, with the exception that they can also be held electronically. And they need to be accessible to folks with disabilities, provide for public comment, and the RMA is required to broadcast all of their meetings online. Meetings require public notice. That's date, time, place, and the subject with some specificity. That notice should be published 72 hours before the meeting, and the RMA is required to publish both online and to do a physical posting. And we keep records of all of the meetings. Now, all these steps of the posting and the minutes and these pieces are managed by staff, but it's important for the board members to know that it's your responsibility under the law that the Open Meetings Act is complied with. So the duty goes to the board members, even though the actions are undertaken by staff. If there's a failure to properly notice or hold an open meeting, the actions taken in that meeting can be invalid. And then if there's an intent to bypass the open meetings requirements, there can be violations of criminal law as well. So public meeting has a quorum. That's for a body of 7 like this. That's 4 board members and a discussion of the RMA's business. So that can include public hearings, county workshops. You'll see that when those come into play, we typically post them. Something to be more cautious about is emails and text messages and the potential for walking quorums, which we'll talk about in a little bit more detail. Things that are not considered public meetings, even though you may have 4 board members or more there, would be social settings, holiday events, dinners, symposiums or transportation conventions, press conferences, ceremonial events. I just caution that even if you're at these events that are not considered public meetings, you want to be certain that you don't take on discussions of RMA business or plan for action or things that could trigger a walking quorum. So walking quorums are when a group of less than a quorum participate in a conversation about the RMA's jurisdiction or business with the intent that you'll ultimately reach 4 or more members, and sort of predicting what the action might be. So the definition is knowingly conspire to circumvent the Open Meetings Act by meeting in numbers less than a quorum for purposes of secret deliberations in violation of the act. In 2018, the Court of Criminal Appeals found that definition lacked specificity, and struck it down until there was more meat put on the bones, which happened, you'll see in that gray box, in 2019. The legislature provided additional stipulations that A board member would commit an offense if they knowingly engage in at least one communication among a series of communication that occur outside of a meeting and that concern the jurisdiction of the governing body, in which the members engaging in the individual communications constitute fewer than a quorum, but the sum of all members engaging constitute a quorum. And there has to be knowledge that that a quorum is being involved, that ultimately a quorum is being reached and would constitute a deliberation. So with that specificity, it's assumed that that this would hold up in law, but I don't think it's gone back to the criminal appeals, Court of Criminal Appeals yet. So the exception to open meetings is when we go into executive session. And typically for this body, it involves either real property or consultation with an attorney. So you can go in, or we do go in for personnel issues as well. You can go in with your attorney to talk about legal advice on various matters, pending litigation, settlement matters, contract negotiations, or other matters of attorney-client privilege. It's not an opportunity to really discuss policy matters or merits of a contract. It's supposed to be limited to specific attorney-client privilege and legal advice. Real property, you're allowed to go into closed session because of the negotiation disadvantage you would have if you were discussing pricing and these things in public. Personnel is an item that you're allowed to go into executive session. And then the security devices or audits is really network security information and things related to Homeland Security. I don't know that we have gone into executive session under that heading, except in the case of attorney-client privilege items. We keep a record of executive session, and we typically do that by certified agenda. And so that is another obligation of the board. The staff organizes that, but that's a board's obligation. So I think we discussed this up front, but knowingly conspire to circumvent the Open Meetings Act is a misdemeanor offense. And so it's something that's worth being mindful of. Public information is the second branch of the open government requirements. And so all of the information that's collected, assembled, maintained, everything that the RMA pays for in any format on any device belongs to the public. And so that's true if it's in your personal email, if it's in a text message. There are a few exceptions to the Public Information Act for draft documents, agency memoranda, attorney-client communication, and again, real estate, third-party propriety information, and the security pieces we discussed before. What's really critical to keep in mind here is that the Public Information Act doesn't distinguish between your personal cell phone or computer and a government-issued cell phone or computer. It's the information, not the device. There is an exception of the Public Information Act during a catastrophe. That's just the period to respond to a public request, not about keeping the public information, but just how quickly we would have to respond to a request. The director's responsibility with regard to public information, this says open records training, so Public Information Act training, as in the same with the open government. That's a course you've got to take online and have the certificate on file. You want to avoid using your personal devices and personal email accounts when conducting RMA business, but if you do receive RMA information in your personal email or on your phone, we ask that you forward it on to your RMA address and that email address, and that way we've got the full record of all RMA business. And in the event there's a request, we can respond accordingly. For employees, the legislature has declared all employees who are transacting official business or receiving public information as temporary custodians of that information. And so similarly, if you receive something on a personal device, you want to forward it to the HCRMA server and make sure that everything that relates to the RMA is preserved appropriately. And the last piece of the presentation deals with the compliance program. So RMAs are required, like all TxDOT partners, to adopt and enforce the internal ethics and compliance program. Celia and Pharr oversee the program, and we require our contract parties to also have an internal ethics and compliance policy. One of the things that we need to do, that we do undertake in support of this program, is the ability for anonymous website reporting. So on the RMA's website, this is a little blurry here, but you'll see the fraud reporting button. So this would allow anybody internal or external to the RMA to report something that they felt was a violation of compliance standards and procedures. Anything that's reported here goes to RMA staff, I think directly to Celia and to Pharr, but I also get a copy of that. And so we've got some checks and balances on that reporting. The RMA also maintains a code of conduct as required, which includes record retention, fraud, equal opportunity, sexual harassment and sexual misconduct, conflicts of interest, the use of RMA property and gifts and honoraria. And then we'll provide, as I mentioned up front, the annual certifications to TxDOT that the ethics and compliance program has been adopted, that we've got our program in place to detect and prevent violations of the law, that we enforce our compliance. And we do this through the written manual, the compliance standards, which are communicated to employees and the board. And then we'll present those certificates as well that outline the board's compliance with all of the requirements under state law. Part of our compliance program is the training evidence. So the certificates we've discussed, there are members of the staff that will take the Public Investment Act training course, and they'll have those certificates. And then other staff members will have project management and billing training certificates from TxDOT. Those are required as part of our project development agreements. And then the RMA presents to various agencies, primarily TxDOT, but not entirely, a number of reports, everything from our strategic plan and annual reports all the way down to the board members presenting their annual personal financial statements to the Texas Ethics Commission. And we used to print the handbook, but it's just an extraordinary amount of paper. So instead of printing it, there's a link on the website. If somebody wants this printed, we certainly could. But the electronic handbook allows you to go directly to all of these resources, and it's a great source if you've got questions about anything we've talked about today. I'm also available to answer questions. But it includes the RMA statute, Chapter 370 of the Transportation Code, and the corresponding rules. It's got conflict of interest information, handbooks on open government. The Ethics Commission produces a handbook on the guide to ethics laws for Texas. And then all of the RMA operating documents, the bylaws, the current strategic plan, we include the budget, last year's audit, and then the various policies that apply to board and staff. So this has been updated and is available on the website if you want to take a look at that. And that is all I have. I'm happy to take questions. Celia will provide you all with the certificate that will comport to what we discussed tonight.
Thank you.
Yep. Vice Chairman, directors, need to call order and establish a quorum for the regular meeting. And since we have some of the members virtually, I'll call out a roll call to see who's in attendance. So Vice Chairman Forrest Reynolds.
Here.
Secretary Treasurer Ezequiel Reina Jr.
Here.
Director Alonso Cantu.
Here.
Director Juan Carlos del Angel.
Here.
Director Frank Pardo.
Here.
Vice Chairman, you have a quorum.
Great. Any public comments?
No, sir, we do not have any public comment.
So we'll start.
Yeah, the next item on your agenda is item 1A, reports on program manager activity for the 365 Tollway project and the IBTC environmental clearance document. Eric Davila will give you a brief report.
Good afternoon. Doing well, thank you. If we go to slide number 5. Let's see. Sure this thing is on. Or maybe you can move it to slide number 5. Just an overall picture of the ongoing activity where, obviously you'll hear a lot more about construction that's ongoing. The big task before us from the development side of the house is implementing the 30 some odd $1 million worth of savings in the construction contract. So that still requires some coordination of, if you can go to slide 5, number 5, with the contractor on the design submittals. Reviews of that are underway. We have 3 packages. One confirming pages that are ready to go. So we're just being very formal about, how we manage this 2,500 plan set of plans, and making sure that if something's ready to go, ready for construction, we have an approval in place for those items. So we're just making sure we coordinate that so that the design side doesn't surprise the construction side. And so that coordination has been very fruitful. We have a couple of additional design packages, 2 and 3, that actually implement some of the design changes. And so we're having the GEC run through the quality assurance checks to those designs to make sure that they adhere to the spirit of the items that we agreed for and the cost savings of VECP. Construction management support, still entails being the go-between on some of the environmental inspection issues that come up on either wetland or archaeological sites that we have to keep track of in the construction of the 365 tollway, and helping out with the reimbursement processing that comes up. The other key ongoing activity is the toll system integrator for the 365 tollway project continues to move forward. So we are looking at something within the next 30 to 45 days. We'll have a final approved set of bid package to go out and start looking at vendor interest in providing the toll system integration. So as you all know, the roadway construction will install a lot of the gantries, a lot of the heavy frame of the actual toll collection system, but the cameras, final cabling and switches that basically are like network items out there, and the things that connect back to the back office, wherever that'll be. And currently that's scoped to be with Central Texas RMA, are included in that procurement package. So it'll provide them all the instructions where information goes, where we're taking information from, and how it gets routed around, so that we can complete our transaction and collect the tolls off of that. Any questions on 365? Hearing none, we'll go to slide number 6. Just the next page, please. Thank you. Just very quickly on that one, we had submitted the final environmental assessment document, as well as a draft notice of availability. So once we get comments back, we have a commitment, hard commitment from TxDOT to get us comments back by this Friday. We're hoping it's good to go, but if there's final comments, we'll address those very quickly. They should be very minor at this point. This document was had already gone through what we thought was a final set of comments, but we did have one technical report that had to be added, and so that had to do with the public hearing. And so since that happened more recently, we understand there may be some comments to that, but it'll be relegated to one small report. And with that, hopefully we'll have environmental clearance rendered here. I want to say we're still targeted towards the early fall for environmental assessment for the, in other words, the environmental assessment process will wrap up. So we'll have in hand a FONSI, which is a finding of no significant impact. Once we have that, we're environmentally complete. We got one very good leg up on calling this thing environmentally complete. We still have permits to go through, but from the completion side, we can start advocating for the project, a lot more diligently with regard to funding, since the next phase that opens up to us once you have clearance is right-of-way acquisition and utility relocation. And for that, we'll need some additional commitments on hopefully this draft UTP plan that's going to be unleashed in the next couple of days by TxDOT. We'll detail hopefully a little more as to dollars either for construction, right-of-way, and utilities that may shake out, as opportunities for the project. And with that, I conclude the project summary. Any questions on the IBTC? Yes, we did submit, and it's included in the report, a mega grant. So the feds published through the Department of FHWA a program. Actually, it's the DOT. So the overall branch has infra grant dollars that they've assigned. We did get approached and encouraged to submit an application with TxDOT. We partner with TxDOT. They took the lead on writing the application. We provided traffic and all the pertinent documents that they needed to complete the package. We'll hopefully get a decision by September. If there's good news to be had, our U.S. senators will be the first to know. And second to that would be you all. So hopefully we submit for a significant portion of the the phase 1 project. And if that happens, there's some additional coordination that'll have to take place on the funding side. It'll be a regional discussion as to how the funding priorities help align to get that project to fruition. But if it gets funded to the amount that we requested, it'll be a good problem to have. It's a significant portion of the actual overall, not just construction, development dollars as well. So we're very hopeful, and it was a very good application. We hope it succeeds for $100 million plus, 100 million plus. Yes. For phase 1, and that would be the actual grant component. There's a breakdown, and we could provide for you how much would be grant provided, how much would be the regional match, and how much TxDOT would pitch in. Overall, it would provide over $150 million for getting the project well into play. So, any other questions? Welcome.
Vice Chairman, Directors, the next item on the agenda is 1B. It's a report on construction activity for the 365 Tollway project. But before Ramon gives his report, I'd like him to introduce our construction record keeping and field inspectors. We're fully staffed on our construction component of the staff out in the field to manage the construction contract. And I'll ask Ramon. They're in attendance today, so I'll ask them to introduce to the board.
Good evening, and thank you for the opportunity. I'd like to welcome the new construction division staff and ask that they please stand upon being called out. We have Mr. Sergio Mandojano. He's a record keeper. He's been with us since the 281 project. We have Mr. Ronald Reyes. He's also an additional record keeper that we have. In the back there, I think they thought we were going to take donations or something, and they sat in the very back. But we have Mr. Gabriel Molina. Mr. Juan Aguayo, Alejandro Alanis, and we've got 2 young engineers fresh out of the garden. We have Javier Trigo and Jessica Garcia. This is our immediate staff. Of course, they're on a probation basis for 6 months, and they're doing very well. We look forward to the challenges and meeting all the requirements. Yes, sir. What's that, sir? Uh-oh. Uh-oh. All right, guys, we got to get some Dodger caps.
Thank you.
With that being said, I'll go on to providing you with the status of the construction project. We can move on to the next. Let me see if this works. Should we point it at the? Okay. All right. So we did let the 12.2 mile section of construction project of the 365 toll project. It is approximately 12.2 miles from the Anzalduas port of entry east to the Pharr International Bridge port of entry. It was let to Pullis Construction for approximately $296 million. We have initiated 3 change orders, all relative to the value engineering change proposals, captured approximately $38 million in savings, or 12.84%, brought the construction construction cost to $257 million, with $20 million in progress payments as an incentive. We are using this also as a form of collateral, or you could say a change order purse to initiate any of the committed values or change proposals that they have submitted. Eric mentioned that we have received the first 3 packets, and we are diligently reviewing those for their effectiveness. And we will be stamping those pages, the effective set, and to be able to capture and document what we're actually building in the field. So that way there's not any issues later down the line that that was not the intent. They have proposed or will be submitting an effective set of plan sheets, and we will be swapping out plan sheets as they get approved. It sounds a little overbearing, but that is the only way we can capture documentation and legitimately have a handset of plans while we're constructing, and avoiding a design bid build, and maintain the design construction build, and avoid any issues and maintain our design bid build statute that we let the project with. As far as the project's overall status, we are approximately 104 days into the project as of today, which is 8.22%. And we're seeking approval of estimate 2 and 3, which will place us at approximately 9% of the overall construction cost. So we are have a slight lag, but that may be contributable, or is contributable, to the fact that our environmental justices are confining us from letting the project, or fully allowing the contractor to get onto the project. We have the wetlands and the archaeological sites that environmental justices that we're addressing. After the holidays, which is July 5th, we will be allowing them to fully proceed onto the project. And they've prepared appropriately. They're ready to go forth with the bents. We are constructing the existing bridge on Highline Road. We do have drill shafts on the south side in the ground already. We're working with 36-inch, 72-inch drill shafts. And upon completion of that bridge, the substructure on there, they'll be moving on to the floodway, constructing bents 2 through 15. And we hope to pick up progress once they get into that area. We also have the proposed wick drains, and starting with the levee construction in those particular areas. On this page, you can see we have 9 approved subcontractors on the project. This was just to inform the directors of who they are and who we're doing business with. It's A.H. Beck, which are doing drill shafts. We have Certified Placers, which are steel tires. The IOC company, who is doing a lot of the foundation, the levee work. We have L&R Precast, which is providing all of the RCP and bridge structures. Well, RCP, and when I say bridge structures, I mean underground culverts, boxes, drainage structures such as that. We have Scott Durr Painting Company, CSA, which will be providing the infrastructure for the toll collecting system. Texas Highway Systems, they are doing the environmental justices as far as installing the silt fences, etc. We have Texas Icon, who is also contributing to the exits. And we have US Menard, who will be doing the wick drains onto the project. With that being said, we move on to the next page, which basically summarizes the overall payout of what we are working. Get that going. We come before you, we've approved payment 1, which was for approximately $23.6 million. The month of May and June, we have $14 million in the month of May, and we've got approximately $2.3 million for the month of June. This is at a 20th day construction cutoff date. We have established this date as our overall policy due to the fact that they want to work and be able to be paid within the same month. So what you will be coming before the board will be a interval between the 16th of the month, a mid-month summary is what we're looking at. So it'll be mid-month of the existing month and mid-month of the future month. So we're cutting off construction on the 15th for pay items and maintaining the cash flow in that. And with that being said, we've got some construction pictures with the prepping of the right-of-way within the floodway, conducting our environmental justices. Once we do prep, we have to put up the silt fences to maintain erosion control onto the site. We've got the drill shaft with the steel tires going in, displaying the 36-inch drill shafts there, the steel cages, the rebar, the operation of excavation, and the overall. The wetland mitigation project is also coming to fruition. The consultants continue to work on bringing this project before the board. Hopefully, we're looking at something next month, and this will be invoking the permit requirements of the Fish and Wildlife for the conservation project that we have with the Sakai property we purchased adjacent to the river. That concludes my report. May I entertain any questions or concerns at this time? Thank you.
Vice Chairman and Directors, the next item on your agenda is a consent agenda. All matters listed under the consent agenda are considered to be routine by the governing body and will be enacted by one motion. There'll be no separate discussion of these items. However, if discussion is desired, that item or items will be removed from the consent agenda, will be considered separately.
Get a motion approved. Second. All in favor? Can everybody hear us
No, sir.
online?
Yes.
Aye.
Aye.
Those opposed? Motion passes.
Next item on your agenda is a regular agenda, item 3A, resolution 2022-41, approval and consideration of agreement for continuing disclosure services between Hilltop Securities, between Hilltop Securities and the Hidalgo County Regional Mobility Authority. This item is to provide continuing disclosure between the authority as part of the Series 2022 A and B bonds that we issued. And so this is a requirement of the bond covenants that we provide continuous disclosure. And so historically on the 2020 Series A and B and the Series 2013, we're required to do disclosure for this, to hire the consultant to perform the disclosure for us on a continuing basis. Typically, this is done on an annual basis is when they provide the reporting for the authority. Staff recommends approval. Yeah, and it's $3,500 per year for the annual and quarterly report to assist staff, or $5,000 per year if they prepare the continuous disclosure.
Second. Those in favor?
Aye.
Aye. Motion passes.
Next item is 3B, Resolution 2022-42, consideration approval of work authorization number 2 with LNG Consulting Engineers to provide geotechnical services for sulfate testing at the proposed bridge locations on the 365 Tollway Project Segment 1. And so in the project documents, we have a requirement to add sulfate resistance to the concrete that we pour for the drill shafts. And so what we're going to do is we're going to test the soils for the reactivity. And if we do not need the sulfate resistance mixed into the concrete resistant additives mixed into the concrete. We'll eliminate those, thus saving project costs. So to do the testing for all the drill shafts is going to be $51,023.48. Staff recommends approval.
What's the amount on that?
$51,023.48, and that's to test all the soils where the drill shafts will be drilled that are requiring sulfate resistant, which is the majority of the project.
Any questions? Take a motion. Motion and a second. Any opposed? Motion passes.
The last item on your agenda is item 3C, Resolution 2022-43, consideration of final closeout and reconciliation to the agreement with Strike for Lone Star Gas Utility Relocation Services on the 365 tollway. The board of directors approved an agreement with Strike to relocate a gas line on the project. The original estimate was $398,922. And upon finalization, there was additional cost, and basically that was to purge the line. This was quite a long gas line, so there was a requirement to purge the line. So there'll be an additional $10,804 cost, or approximately 2.7% increase. So staff is recommending change order number 1 in the amount of $10,804 for a total cost of $409,726. Staff recommends approval.
Get a motion. Second. All in favor? Aye. Those opposed? Motion passes.
And just to make a note that the authority is responsible for these utility relocation costs for this particular relocate. So we were responsible.
Yeah, we talked about that.
Yeah.
When was that? 2021 or 20?
20, yes, sir. 21.
21.
21, yes, sir. And that's all the business we have for the board's consideration today, Vice Chairman.
Thank you.
Yes, sir.
Thank you. Thank you, Pilar.
Have a good evening.
Thank you, directors.